Good afternoon, everyone. I'd like to welcome you all to today's John Dossiter Health Ethics Seminar featuring Rose Carter. She'll be speaking today on telemedicine, ethical and practice issues for confidentiality of patient information. Before beginning, I'd just like to remind people that during today's seminar, we'll be keeping everyone's microphones muted. Please feel free to type any questions or comments into the chat box. After the presentation, we'll have a period for discussion, in which time people can unmute the microphones and we'll address the various comments and questions in the chat box. I'd like to also remind people that on the Dossiter website is a form for providing your feedback about today's session, as well as providing suggestions for future seminars. So at this point, I'd like to introduce Rose Carter. Rose Carter has extensive history in health law. She works for Dentons and is an adjunct professor in the Faculty of Medicine and Dentistry with the John Dossiter Health Ethics Center. I can't do justice to her CV in the course of a couple of minutes, but would certainly just like to highlight not only does Rose Carter have an extensive experience in health law, she has an extensive history of supporting the education of medical students and other learners in the Faculty of Dentistry as they learn about health law and their professional practice as physicians. Rose is no doubt a highly sought after speaker, and we're very fortunate to host her today. Without further ado, I'd like to turn things over to Rose.
Thank you very much, Michael. And for those listening, I will be saying next at the end of one slide, so don't be thrown off by that. As Michael did, I would like to thank you all for taking time to join us today. During my talk today, I will strive to highlight the advantages and difficulties with telemedicine. Telemedicine was used to a certain extent in Canada, but in a very limited way, mainly because colleges of physicians, surgeons across the country had not approved the use of such in many instances. Prior to COVID-19, physicians would certainly use communication such as telephone or cell phone to call patients, perhaps to give test results. But with the onset of COVID-19 and the lockdowns that we faced, many of us, I think, forget or are so focused on COVID-19 and its dramatic impact on our lives, we tend to forget that there are thousands of people in Canada that had medical conditions prior to COVID-19, which have nothing to do with COVID-19, and others have developed health conditions unrelated to COVID-19 since its onset. And those patients still require the services of the medical community on an ongoing basis. So telemedicine is one of the ways to assist patients in connecting with their healthcare providers. However, as I will share with you today, there are numerous pitfalls, and those who are unaware of the needs for security ethics in the practice of telemedicine can find themselves in difficulties with their regulatory bodies. I predict that over the next few years, there will be a wave of complaints to the Privacy Commissioner, complaints to the College of Physician Surgeons, as well as other regulatory bodies such as the Nurses College, which regulates nurse practitioners, and other college-related members in the medical sphere regarding concerns with how the telemedicine interaction with a healthcare professional was faulty in numerous ways. Next. So basically, aside from handwritten or typed consultation reports and other medical data that's reduced to paper. Telemedicine is basically any communication with a patient that is not in person. And for those practitioners who have been taught to deal with patients face to face, often many of them find challenges in having to render professional advice and make diagnosis and provide a course of treatment through the use of telemedicine. Next. Informed consent is not new to the medical community. It has been around for decades, formalized through the Supreme Court of Canada's decision. Prior to engaging with a patient, taking their history, etc., the patient must give an informed consent to the interaction with the healthcare provider. Throughout this presentation, I will probably more often than not refer to physician, and when I do, please assume that I am referring to healthcare providers who are able to offer medical services to patients. In telemedicine, unlike face-to-face encounters where a patient goes to emergency department or is an inpatient or goes to a medical clinic to see a physician, the patient has to connect on a website with the physician, aside from use of the ordinary telephone, obviously. So for medical professionals who offer medical services through telemedicine, it is important that their website meet all the requirements set out by the regulators in the security of the website. The patient should be able, by going onto the physician's website, be able to ascertain the security of their data and how that's going to be protected, and the limitations of telemedicine, as well as its advantages. Both the patient and the physician must share with each other their physical location. So if the patient is in Vancouver, for example, and the physician is in Edmonton, the physician must disclose where they are, and the patient must do likewise. It is very important that the healthcare provider, as soon as possible in the interaction with the patient, determine whether this patient's condition is suitable for telemedicine and why it is or why it is not. Medical records in interactions with patients are crucial, both ethically and legally. So in addition to the normal notes that are made with a face-to-face encounter with a patient, the physician has to add additional information into the patient record, such as noting his location or her location and where the patient is located, and ascertaining from the patient and noting this that the patient is aware of the limitations of telemedicine, and on what basis the healthcare provider determined that this particular interaction with a patient was suitable for telemedicine. A portion of the interaction with the patient may be suitable for telemedicine, but another portion of the interaction may not be. Very careful notes have to be made of those decisions. Next. I've touched on privacy to a certain extent, but privacy is much more heightened in the practice of telemedicine. For one thing, the patient information is not being given in a closed examination room. It is being given through some sort of network facility. In setting up telemedicine, healthcare providers should be very aware that they are dealing with ethical and professional telemedicine providers. They must know and understand where the patient's medical information is going to be housed. Is it going to be in a cloud? I was just dealing with a file the other day where the patient's personal information is going to be housed in Ireland. Now, most people would not think when they're interacting with a physician about where their personal information is going to be housed. But if there is a breach in that medical information, it could be very costly to the patient from an emotional point of view, from a cost in relation to healthcare insurance, for example, and just the general knowledge that his or her very personal private medical information is now in the public domain. In the use of telemedicine, the patient cannot be charged if the service is for a publicly funded service. So certainly in Alberta, when patients see physicians, almost all of the interaction is paid through Alberta Health Services. In other words, our government, because we live in a socialistic society where our health care is publicly funded. This is not an avenue for healthcare providers to be charging patients outside the healthcare funded service where such is not allowed in a face-to-face encounter. Also, healthcare providers may find during the course of the interaction with the patient that the patient must be referred to a specialist, for example, or to an emergency department. And if that's the case, the physician has ongoing obligations to be certain that at the end of the call, the physician is properly referring the patient to an emergency department or a specialist. This is no different from a legal, ethical, and regulatory obligation than it is during face-to-face encounters. Test results. Patients are often used to returning to physicians' offices to secure their test results, again in a confidential setting. How is the patient's results going to be reported to them? Are the patients going to be able to go to a portal to determine their results themselves? Is the healthcare provider going to follow up with the patient in the same mode that the initial encounter occurred to discuss their test results? Also, because so much of our communication with each other when it's in person relies on body language, when providing services through telemedicine, such is not so evident. And so the healthcare provider has to be, I think, more aware of the limitations of video interaction, for example, with a physician or physician's family. With the patient's family. And talking about interactions, obviously the healthcare provider must be certain that at their end of the communication, there is absolute privacy. It's not a good idea to be doing this at the dining room table with spouse and children running around. The patient has to be assured of the same privacy that they would be in a face-to-face encounter in a physician's office. If the healthcare provider has other healthcare professionals with them present during the telemedicine encounter, they have the obligation and must tell the patient who is present, why that person is present, and secure the permission from the patient that that person may remain during the encounter. Test results are often forgotten during telemedicine encounters because the patient is not booking through the usual telephone call to the physician's office. And recently I saw an instance where there was over 1,000 laboratory results that had not been seen and thus obviously not opened by the treating physician. This is of grave concern to the College of Physicians and Surgeons and must not occur. The regulators, I anticipate, across Canada are going to be very busy in the coming years with dealing with these types of complaints from the public and fellow healthcare providers. Next. Number of interactions with patients. This slide deals with the requirements put out by the regulator. For example, in Alberta, a physician from another province treating an Alberta patient through telemedicine is limited to 5 interactions with that patient per year, unless it is an emergency situation. What I'm seeing in the area of telemedicine is not issues at this point with too many encounters with patients through telemedicine. What I'm seeing is that patients are often not having repeat interactions with the healthcare providers. I don't know the genesis of that, but I do suspect, based on my experience, is that physicians, for some reason, just view this as a one-time encounter, sort of like an emergency department situation, rather than an ongoing patient relationship. That should be at the forefront of the physician's mind and the patient's mind. The patient may also just see this as a one-time encounter when in fact the patient's condition merits ongoing care. Again, the physician has to note in the patient's record that is being created simultaneously with the visit what the patient is to do in relation to follow-up. How the patient is going to access their test results, when the physician needs to interact with them again. Healthcare providers also have to be aware of the scope of practice that they are licensed for. When we're dealing over video, it's very easy to slip out of the professional mode of behavior and sometimes cross boundaries that we would not cross meeting face-to-face, in my case, with clients and with healthcare professionals, their patients. I've discussed the referral of the patient a bit, but from the patient's point of view, the patient needs to receive some sort of written communication, whether that's through email, of the name of the physician or entity that they are being referred to. It has to be clear in the communication between the referring healthcare professional and the receiving specialist, who is going to advise the patient of the time and place or of their interaction with the specialist, and whether that's going to occur via telemedicine or in person. So as you can see from what I've said so far, there are many added layers to interactions with patients in telemedicine that are not necessary in face-to-face encounters. So for those who are thinking of offering telemedicine services, I would suggest that it's very important that you sit down, construct a cheat sheet for yourself of all the extra steps that must be taken, and review your notes carefully at the end of the telemedicine interaction with the patient to be certain that you have noted all those salient points. Next. So physicians practicing in Alberta, some of them want to offer services to patients outside of Alberta. So for example, if a healthcare provider is interacting with a patient in Ontario, it is expected that that medical person would advise the patient where they are licensed. I'm only licensed in Alberta. I'm not licensed in Ontario. But for the physician offering services to patients outside of their home jurisdiction where they're licensed, it is necessary that that healthcare provider be familiar with the standards and guidelines of the College of Physicians and Surgeons or the nursing college in the province or territory outside of which, outside of their own territory where they are offering medical advice. Records, I can't keep stressing the importance of very good record keeping in these circumstances and where the records are housed. Colleges across the country are still receiving calls from physicians prior to use of telemedicine and ongoing now, where a physician will call and say, I had my laptop in the trunk of my car was broken into and the laptop was stolen. What should I do? The first thing your regulator is going to ask you is if the medical information of your patients was encrypted or not. And regulators across the country tell me that more often than not, the answer is that information was not encrypted. If that is the case, the privacy commissioner in the respective province or territory will take a very, very dim view of the lack of security of that personal medical information. On referring a patient, again, for example, say a physician is interacting with a patient in Ontario and they're going to refer them to a consultant. The patient must understand, are they being referred through telemedicine to a consultant in Ontario, Quebec, BC, or Ontario, or where is it? You can't make assumptions that the patient will understand the location of the specialists that they are going to see. Know your College of Physicians and Surgeons regulations on record keeping, on security of records. Know when you're going into the practice of telemedicine, unless you're doing it through a government-run institution such as a large hospital, that you are going to have to pay extra costs for security of data. This is crucial, and I anticipate we will see lawsuits in this regard. I keep mentioning that, but I anticipate that there are going to be a lot of lawsuits in the future because safety of patient data was not dealt with, either due to ignorance on the part of the practicing medical professional or the prohibitive costs that they face. I'm often contacted by physicians wanting to start practicing telemedicine, and everything goes on fine during the conversation until I come up to the point of discussing data security and how they need to have experts in data security involved in setting up their telemedicine practice. This service does not come cheaply. It can be very costly, but it is absolutely necessary in dealing with telemedicine. Next. Understand and know your code of ethics in the province in which you practice, whether it's Alberta and you're treating patients in Ontario, Quebec, or anywhere else in Canada or internationally. It's important that you not only rely on your home province college's code of ethics, but that you know the code of ethics of the province in which you are treating patients. All colleges across the country and territories have some form of standard of practice and or guidelines for dealing with telemedicine. Because this is a rapidly evolving practice area, which has very much escalated during this COVID time, you must keep checking on a regular basis with your regulator to see if the standards of practice or guidelines that they have in place today are still the same, or if they have changed, because the regulators are having to pivot very quickly to deal with this exploding area in the practice of medicine. So they will be updating and are updating standards and guidelines in some provinces on quite a regular basis. Next slide. Prescriptions. Under no circumstances are new prescriptions for opioids allowed. And I'm going to come back to that in a few minutes, but I want to highlight that. And the same applies for medicinal cannabis. You must know the respective college's standard in relation to prescribing cannabis and opioids through telemedicine. No prescription must be provided to a patient through telemedicine interaction unless the following has occurred and is documented: that a full history is obtained from the patient and is documented carefully, and that the source of the medical history is reliable as the physician can be sure it is, and the sources. So for example, if you're providing medical care to a minor, it's likely that the parent will be there. The minor, if they're of a cognitive age, will be telling you what is wrong with them from their perspective, but their guardian, be it mother, father, or legal guardian otherwise, a relative, or if they're under the care of social services, you must note the name of the person who is providing you with the patient's history. Next slide. You must be able to demonstrate objectively to your regulator or in a court of law that prior to writing a prescription for the patient, that an appropriate examination was performed. This is a very challenging area in the practice of telemedicine. Some physicians will have relationships with other healthcare providers who can attend at the patient's home to provide a hands-on examination under the direction of the physician. This all has to be carefully documented. That health provider's name, the type of information that was given to that healthcare provider who was acting as proxy for the physician through the performance of a physical examination. As I said earlier, most physicians practicing today have been trained through the laying on of hands. In other words, physically seeing the patient listening to the patient's chest, palpating the abdomen, whatever it is that the presenting condition requires. Again, physicians have to be aware of the limitations of an examination through telemedicine, relying on the patient's description of their abdominal discomfort, their cough, etc., and always having at the forefront of the practitioner's mind the limitations of this type of interaction. It's very important to note in the contemporaneous patient record of the limitations of the examination that was performed and the reliability of the findings. Next slide. Again, with prescriptions, obviously it goes without saying, but you would be surprised in my practice how often I don't see a diagnosis written down, but I see a prescription was issued. And this is not something your regulator or court of law wants to see. Just because you're prescribing medication through telemedicine does not take away the concerns that you would have in doing so in a face-to-face encounter. You must have a diagnosis. If you've got a concern that the diagnosis you have arrived at may not be the proper one, for example, at the moment it does not appear that the patient has pneumonia, but is that condition evolving? You all know much better than me that many medical conditions take time to evolve. Do you have a differential diagnosis? And if you have a differential diagnosis, is the prescription you're ordering going to cover that differential diagnosis if that in fact turns out to be the actual diagnosis? And how are you communicating the limitations of that particular prescription for the current diagnosis that you've arrived at to the patient? In a situation like this, obviously follow-up is very, very crucial. And when you've advised the patient to follow up should be noted in your record. Obviously, the name of the medication that's being prescribed, the length of time it's being prescribed for, should be clearly noted on the patient record. And obviously, patient record is going to be an electronic record, unless you're phoning a patient that you've had face-to-face interactions with before from your office and you're using your usual paper chart. Next slide. As with any prescription, ensure that there's no contradictions to the medication that you're prescribing. Just because the patient didn't have an allergy to a certain medication the last time you interacted with them, or the last time they interacted with another healthcare provider, does not mean that they have not developed a sensitivity or an allergy to the medication at this point. Obviously, if it's a new medication that the patient has never taken before, the possible allergy reactions have to be carefully explained to the patient. Again, if you're treating somebody in Ontario, for example, what are they going to do if they have a reaction to the medication? How are they going to be in touch with you? How are their needs going to be met after the telemedicine interaction ceases? The concern in relation to the prescriptions that are prescribed obviously depend on the history and the sources of that history. So for example, if you're a receiving physician as a specialist, for example, another physician has referred a patient to you, it is assumed that you would have received some sort of communication, preferably in writing, electronically, through telemedicine of the patient's history and the problems noted by the referring physician and why it is that they need you, you need that physician's interaction with your patient. Next slide. I can't stress enough that the risks, benefits of a prescription be carefully explained to a patient, and again, carefully noted. During the course of my discussions with you so far, you will have noted that much of what I'm saying applies to everyday interactions with patients, but it's much easier in telemedicine to become more lackadaisical and not as careful as you might have been in a in-person interaction, where you're moving on to the next video call. You may not be that conversant with technology. I certainly am not. And so you leave the electronic record incomplete and forget to go back. You're not going to be in the same situation as you are seeing patients in an office at the end of the day, where you're sitting down with paper charts and going through those. And because telemedicine is relatively new, and as I can't stress enough, has exploded during COVID-19, regulators are going to be scrutinizing medical records very, very carefully. What is the patient to do if a risk materializes? Often physicians will say, well, just call my office if something occurs, but that may not be available to the patient after a telemedicine encounter. So much more thought, I suggest, has to be given to the possible issues that may arise after you click off with the video interaction with the patient. And again, a careful note made of what your advice to the patient was. Next slide. You can have more comfort in prescribing for patients and in the area of opioids. You can prescribe opioids if it's done in consultation with another health care professional. For example, you've checked with the patient's prior physician, and you see that or learn that that physician has prescribed an opioid for this patient before. For the same condition the patient is consulting you about. In that circumstance, you would be allowed by your regulator to prescribe an opioid, but you're going to have to be able to justify that. It's very important to try to access as many medical records for the patient as possible, and determine whether this is a routine visit with the patient or if this is an emergency situation. Obviously, if you have to prescribe pain medication of some sort in an emergency situation, that prescription should be very limited and only given for duration until the patient can attend with a healthcare provider face-to-face, and the patient must clearly understand that need. Next slide. I'm sure that you are becoming very fatigued at hearing about record keeping. But because I've defended physicians for decades now, I know how important record keeping is in defending yourself, both from an ethical point of view and a standard of practice point of view. And with telemedicine, this is only heightened, as I have repeated repeatedly said during this time with you. There's added concerns, privacy issue, ethical issues to do with the privacy issue. What happens if your website collapses? What happens if there's a data breach? What happens if the company that you are have contracted with to house patient data goes out of business? They just close up shop one day. They go bankrupt. What is going to happen to that data? I strongly, strongly recommend that before entering into any contract with any electronic data protectors, that you secure the services of a lawyer conversant with data protection to be certain that you are covered as well as you could be in that contract, because it's not going to help you at all with the regulator or in the court of law to say, well, I left that patient record in the hands of the data provider. You're going to have to prove through documentation, through contracts, that you did due diligence prior to entering into a contract, verbal or otherwise, with that data provider. And I would certainly recommend that it not be a verbal contract. Everything should be in writing. You need to know from the contractor where the patient's medical information is going to be housed. Housing data in a cloud is seen by professionals dealing with big data to not be as secure as storing it otherwise. Who is the data going to be shared with? You know, under the Health Professions Act in Alberta, that there are custodians and other individuals who are entitled to access that information. Most of you are familiar, if not all of you are familiar with Netcare and how that works and how information is shared through that mode. Very important to a patient is, how does that patient access their records? Now with, and in the past with paper records, if a patient wanted a copy of the record, they would phone the physician's office and ask for a copy of their chart to be produced, photocopied, and they would go and pick it up. The same thing has occurred even when physicians have electronic medical records in their office. They print off a copy of the patient's electronic record, and the patient comes and gets it from the office. It's been very uncommon for a healthcare provider to feel secure enough to just email the patient's record electronically. And that mode of transmitting of patient records has to be seriously considered and done in a very secure fashion. All you can do is do due diligence in this matter. You will be protected from accusations to your regulator if you can prove through written contracts, etc., that you did everything professionally possible to do to secure the data, and the breach of security was not your fault whatsoever. Next slide. Devices. You're going to be using a third-party provider. They should be reputable. You should check with the AMA to see if they can recommend certain providers. Be certain that the provider of the device is recognized, reputable provider. Is the provider insured? If there is a data breach, who's going to pay for that? And what is going to be the cost to transfer information between healthcare providers and from the patient to the provider and from the provider to the patient. All of these have to be carefully considered and decisions made in an informed way and documented very carefully prior to agreeing to use a certain device from a certain provider. We all know that there are the cheap burner phones out there. You don't want to be using one of those. You want to be using a iPhone or whatever your device is that is sold by a very reputable provider. All of these matters come into the ethical domain. Are you acting in the best interest of the patient that you are providing services to? Not only are you meeting the standard of care, but are you dealing with concerns about how the medical information they share with you, what they believe to be in a secure, confidential space, remains such. Next slide. What are you going to do if you learn of a breach? I highly recommend that you immediately contact your regulator and your insurer. For physicians, they belong to a mutual defense fund in Canada, so that's Canadian Medical Protective Association. You should immediately contact them and contact your regulator prior to contacting the patient. This has to be done very quickly. Secure advice before you contact the patient, but the patient has to be contacted in a timely fashion. You may be advised to report to the Privacy Commissioner and understand that there may be reputational consequences for you depending on how the breach occurred. Also, when we see our physicians, we often share information with our physicians about our loved ones. And that information is often quite properly noted in the patient record. So if there's a breach, not only will the patient be looking to you for explanation as to how and why their medical information was breached, but any third party that is referenced in the medical record will be looking to you as well, and that third party may well sue you, may well report you to the Privacy Commissioner or report you to the college, to your college that regulates your practice. This is not a time to bury one's head in the sand. This is something that has to be dealt with like a raging fire. You have to deal with this immediately, because how quickly you deal with it, how quickly you reach out for help, how quickly you report this breach to the proper authorities is going to be scrutinized as the breach and its consequences are dealt with down the road. And so you have to document what you did, the date, and preferably the time as well, who you spoke with, what you did, and when you reported to the patient and how you reported to the patient, and what you told the patient you would do in follow-up and to keep them informed. All of acting in that manner is going to hold you in good stead when those who have power over your practice are looking at how and why a privacy breach of sensitive patient information was breached. Next slide. We are now at the question phase. I'm happy to answer any questions that you have. Michael has laid out the format for how those questions will be dealt with. So Michael, I will turn the proceedings over to you at this point. Thank you.